Thank you very much. Yes, please. Thank you so much. Right Honorable Chief Justice of the Republic of Rwanda, who is also our chief guest, Honorable Minister of Justice and Attorney General of the Republic of Rwanda, Dr. Emmanuel Ujjasebuja, Honorable Thabo Chakaka Nyirenda, the Attorney General of the Republic of Malawi, Chief Justices Emeritus, Professor Sam Rujeje, and Dr. Naukuri Faustin Nteziryayo, Dr. Stanley Alexander, the President of the ICCA, our own President of KIAC, Engineer Dr. Alexis, Professor Liz Bosman, ICCA Executive Director, Professor Mohamed Abdel Wahab, SIAB President, our distinguished guests, ladies and gentlemen. It's my absolute pleasure and honor to welcome you to this joint conference. Just to tell you that we have a long day, and I will ask for your support for us to be able to move and do a good job here today. Without taking much of your time, may I take this opportunity to welcome the Secretary General of KIAC, who will give us an opening remarks, and then he will invite the next panels, and we'll take it from there. Thank you. You're welcome, Secretary General Victor Mugabe.
Thank you very much, MC. Thank you very much. The Right Honorable Chief Justice, Lady Justice Domitira Mukantaganzwa, Honorable Minister of Justice and Attorney General of Rwanda, Dr. Emmanuel Ujjasebuja, our friend, close friend to Rwanda, Honorable Thabo Chakaka Nyirenda, the Attorney General of the Republic of Malawi, Your Lordship, Chief Justices Emeritus, as she said, Professor Sam Rujeje and Dr. Faustin Nteziryayo, Dr. Stanmil Alexandrov, the ICCA President, Professor Mohamed Abdel Wahab, our close friend and President of Chartered Institute of Arbitration, Chartered Institute of Arbitrators Global, but he has some other country representative here, like the President of SIAB Rwanda and SIAB Zambia, the Chairman of the Kigali International Arbitration Center, Dr. Alexis Ujjasebuja, Dr. Gaston Kenfak, our friend as well, the President of the African Arbitration Association. So you are a guest, but also you are a host, because the African Arbitration Association is hosted here in Kigali at the Kigali International Arbitration Secretariat. Representative of local and international partner organizations here. The list is very long, so I do apologize for not listing each and everyone, but the list is very long. Distinguished delegates, ladies and gentlemen, all protocol observed, good morning. It gives me a great pleasure to welcome you all here at this conference. It was a long but a very amazing journey working with the ICCA Secretariat to have this day happen. Thanks very much, Liz Bosman and your team and the President, Alexandrov. So I would also like to proceed with my remarks by introducing some of our local and international partners that have worked with us in making this event happen, because we are KIAC at the Secretariat, the ICCA, but without you here, without some close friend, we wouldn't really make it. So please allow me to thank some of them that have been very key in this process, by starting with the government of Rwanda for having created an amazing environment for accessibility to the country, but also providing various support to make sure that you enjoy a safe and pleasant stay in this country, especially those international delegates. So I really thank the government of Rwanda, now represented by the Honorable Minister of Justice and Attorney General. I also thank the Office of the Chief Justice, Lady Justice Domitille, who have been very supportive in this process for the ideas involving the judiciary, the judges to come, and ideas that we got from your office were really appreciated. Honorable Minister of Justice and your office, you have been very, very tremendous in this process. The President of SIARB, Professor Mohamed Wahab, have been everywhere talking on our behalf. Thank you very much, Mr. President. Very much, and I wish you fruitful conference, and I take this opportunity to invite my President, Dr. Stan Mill, to address the audience. Thank you very much, my Lady Justice. Thank you.
Ladies and gentlemen, friends and colleagues, good morning. It is a real pleasure to be here with you in Kigali and to open this joint ICCA KIAC conference. First, my sincere thanks to our hosts at the Kigali International Arbitration Center, to the Secretary General, Mr. Victor Mugabe, and the whole team. Thank you for the warm welcome and for bringing us all together here. Next, I want to recognize and thank the program committee for this conference and the three co-chairs, Meg Kinnear, Thierry Ngoga, and John Ohaga, for their work in shaping the program of this conference. And of course, I must recognize and thank the Chief Justice of Rwanda, the Right Honorable Justice Domitille Mukantaganzwa, and the Minister of Justice and Attorney General, Dr. Emmanuel Ugareshebuja. We are honored and grateful for your presence and for your contribution to this conference. This conference brings together a remarkable group: practitioners, academics, judges, counsel, and students from across the continent and from around the world. The diversity of experience is exactly what makes conferences and gatherings like this so valuable. The theme we're exploring today is International Arbitration in Africa, Untold Stories. And it gets right to the heart of something quite important. We know the stories that tend to be told. They appear in academic publications, in casebooks and newsletters. They are discussed at conferences. But we also want to bring into the conversation the untold stories, stories of innovation, of challenge, of change, wherever they come from and however they are being shaped. And we are here today because we're interested in all the perspectives, told and untold. And Africa is an excellent place to do this. Across the continent, arbitration is not just being discussed, it's being actively developed and driven forward. Arbitration institutions are gaining strength and recognition. Bar associations, law faculties, and training centers are investing in the next generation. Counsel and arbitrators are tackling new and complex disputes with insight, creativity, and confidence. There is no shortage of knowledge and expertise, and there is a strong momentum. And these are the stories that deserve more attention, and not only in this context. The lesson we will learn here today will carry weight far beyond any single region. This conference gives us a chance to learn and to engage, to broaden the discussion about the future of international arbitration. And we at ICCA see our role as supporting that discussion. Our goal is to make space for more voices and for deeper exchange of views. So thank you again for hosting this conference. I was informed that we have over 300 registered participants. The sheer number of registered participants already speaks volume about this conference. We are very pleased to be here in Kigali, in Rwanda, in Africa, and we look forward to a day of thoughtful discussion, fresh perspectives, and stories told and untold that will shape the future of international arbitration. Thank you very much. I will now, in a moment, give the floor to the Executive Director of ICCA, Liz Bosman. But before that, I do want to invite everybody to pick up a copy of our latest publication, which is on the table outside. It's a Kigali Special Edition 2025, and it's a drafting source book for logistical matters in procedural orders. Thank you very much. Liz, you have the floor.
Honored guests, speakers, and delegates, thank you so much for receiving us here today. Now, ICCA's mission has always been a global one, and I've been fortunate to be involved in ICCA's enhanced engagement with African practitioners, African judges, and African issues over the last decade. Our first African Congress in Mauritius in 2016 provided the impetus for increased activity by ICCA on the continent. So this initially took the form of a new African working group within the ICCA Governing Board and the ICCA Bureau, led by prominent African scholars and practitioners. This working group played a key role in the establishment of the first ever Pan-African Arbitration Association, which was launched in Côte d'Ivoire in 2018 after a series of consultative meetings held in Mauritius, Abuja, Cairo, and Kigali. I see many founding members of AFA in the audience today, including the past President, Chief Bayo, and current President, Dr. Kenfak. And AFA, as Victor has mentioned, is proudly headquartered right here in Kigali. ICCA's work has also touched on African judges. Our judicial outreach program, which we call our New York Convention Roadshow, has so far engaged in dialogues with judges in 10 African jurisdictions on the enforcement of arbitral awards. So seminars included a really spectacular inaugural event, which was hosted by the Chief Justice of Mauritius in 2012. We've held several North African events in Egypt and Morocco. We've held sessions in East Africa, in Ethiopia, Tanzania, and Rwanda. There was a visit to Zambia on the shores of the Zambezi River and one to the Seychelles. There was an online session with Ghanaian judges during the COVID-19 pandemic lockdown, and a very memorable hybrid bilingual French-English event hosted in Cameroon through the good offices of Dr. Kenfak. So during these dialogues, judges tell us about the particular issues that they confront in their jurisdictions with regard to the enforcement of arbitration agreements and arbitral awards. And our colloquia make use of ICCA's Guide to the Interpretation of the New York Convention, which is now available in a second edition, including English, French, and a number of other languages spoken across this continent. ICCA also engages with young African practitioners. Young ICCA has held at least 20 workshops dealing with skills training topics on the continent, and continues this tradition tomorrow with a practical workshop for young practitioners on the enforcement of arbitral awards. Together with the Permanent Court of Arbitration, ICCA has a long-standing relationship with the University of Cape Town, where PCA and ICCA staff members teach the LLM arbitration class to a very diverse student body. Graduates drawn from that program serve fellowships at the Peace Palace and have included graduates from Kenya, Nigeria, South Africa, Uganda, Zambia, and Zimbabwe. They come to The Hague and bring unique perspectives to our work, in most cases returning home to invest those heightened skills in the commercial offices and the policy-making bodies of their own jurisdictions. ICCA publications would also not be the same without input from African legal practice and African legal systems. The ICCA Handbook, which is a collection of country reports and legislation, as well as the ICCA Yearbook, which publishes court decisions on the application of the main arbitration conventions, include coverage from multiple African jurisdictions. You'll have seen that in the lead up to this conference, we collated new legislation, new court decisions, recent arbitral awards, and opinion pieces from jurisdictions all over this region. which conference delegates will have received in your email. So engagement has always been a two-way street. Perhaps the jewel in our African crown for 2025, however, will be the launch of a new historical database of African dispute resolution later today. This database creates a unique, online, searchable collection of dispute resolution processes spanning around 200 years, about which more this afternoon. And now I will be delighted to introduce the program co-chairs of today's conference, Meg Kinnear, and perhaps I can ask John O'Haga and Thierry Ngoga to stand up and be recognized. And I invite Meg to come and say a few words to you. Thank you so much.
Justice, Minister of Justice, honorable guests, good morning. Almost 2 years ago, ICCA asked my colleague John O'Haga, Thierry Ngoga, and myself to act as program coordinators for today's conference. And the challenge they put to us was to do something unique, maybe even a bit provocative, and certainly something informative. Once we landed on the theme of untold stories, we knew we were on the right track. We have been blessed with tremendous partners in this endeavor, and we want to acknowledge in particular Victor Mugabe and his colleagues at KIAC in particular, who have done a huge amount of work and have also been inspirational in this journey. In many ways, KIAC is emblematic, I think, of the growth of international arbitration in Africa. You may not know that, in fact, the first Arbitration Act in Rwanda was 2008, and KIAC followed soon after in 2012. So from a relatively recent beginning, they have made enormous strides, and we are so pleased to partner with them. In the last few weeks, we have published several blogs, and they are hoped to pique your interest in the topic and get you thinking about all of the things we'll talk about today. And if you haven't taken a look at them, I'd encourage you to do so. We are then honored, of course, to begin the proceedings with an opening by Chief Justice Mukantaganzwa, who herself is an architect of the most innovative Gacaca courts, a drafter of the 2003 Rwandan Constitution, a law reform expert, and now, of course, Chief Justice. That will be followed by a keynote from the Attorney General, Dr. Emmanuel Ugirashebuja, who has also played a key role in East African courts as a Dean of Law and in the development of the justice system in Rwanda. He has a real understanding of the role of arbitration in Africa and has been a huge supporter of the discipline. So we thank you both for gracing us with your presence today. The next portion will be our panels. And as you can see, our moderators and panelists all bring huge expertise, insight, and diverse vantage points on international arbitration generally and in Africa. The program is designed essentially to cascade from law reform to the economic context in which we all work, to innovations in dispute resolution, and finally, a look at the future. So we are very grateful that they have agreed to share their thoughts with us, and we are told that they all have a few untold stories to share with us over the days. Finally, our colleague Funke Adekoya, who is here, will close the conference. So we will not keep anyone in suspense any longer, other than to wish you an interesting, thought-provoking day. We hope and trust you will share your thoughts, your ideas, and maybe even a few of your own untold stories by the end of the day. We thank you so much for joining us. Thank you.
For the informative introductory remarks that you've made. Now, before I invite our chief guest, I'll say that after the chief guest giving her remarks, we are going to have a group photo, and our protocol will be available to guide us. And I request the front two chairs, 2 rows from this side and this side, to join our chief guest and the panelists here for a group photo. Now, without taking much time, may I take this opportunity to invite our chief guest, Right Honorable Chief Justice of the Republic of Rwanda, to give your remarks. Thank you so much. You're welcome.
Honorable Dr. Emmanuel Ogirashebuja, Minister of Justice of the Republic of Rwanda, Honorable Thabo Chakaka Nyirenda, Attorney General of the Republic of Malawi, Honorable Professor Sam Rugege, Chief Justice Emeritus, Honorable Dr. Faustin Heziryayo, Chief Justice Emeritus, Honorable Dr. Stanimir Alexandrov, President of the International Council for Commercial Arbitration, Honorable Professor Mohamed Abdel Wahab, President of the Chartered Institute of Arbitrators, Honorable Dr. Gaston Kemfak, President of African Arbitration Association, Honorable Dr. Alexis Sengumuremyi, Chairman of the Kigali International Arbitration Center, distinguished speakers and delegates, the management of ICCA and KIAC, learned arbitrators, members of the legal and arbitration community, ladies and gentlemen, all protocols observed. Good morning. It is with honor that I welcome you all to this potent conference themed Africa and International Arbitration, Untold Stories. This gathering is both timely and essential, and I thank ICCA and KIAC for organizing this event. As custodians of justice, we are called not only to uphold the rule of law, but also to give voice to the stories too often left untold. The innovations, the reforms, and the quiet revolutions taking place in Africa's dispute resolution landscape should be internationally recognized. Across the continent, countries have been reforming arbitration laws, modernizing legal infrastructure, and strengthening institutional frameworks in order to promote a more efficient, credible, and investor-friendly environment. These reforms are not only legislative exercises, they are bold steps toward African ownership of arbitration as a legitimate and more trusted means for commercial justice. Rwanda has made deliberate efforts to embed arbitration in our justice system. Our judiciary supports arbitration not as an alternative to justice, but as an appropriate component of it. The Kigali International Arbitration Center is a testament of this commitment. We have created an enabling environment where arbitration agreements and arbitral awards are respected and enforced. As our economies diversify, investment flows increase, and cross-border commerce expands, the need for trusted, localized, and efficient dispute resolution mechanism becomes even more urgent. Arbitration is not only a legal tool, but also an enabler of economic growth, investor confidence, and regional integration. At its core, arbitration is about fairness, expertise, impartiality, and a party-led dispute resolution process. Yet, it is no secret that arbitration seated in Africa or administered by African institutions still faces a perception gap. There is still a bias that arbitration in Africa is somehow less credible or less competent than that conducted elsewhere. This notion, rooted more in outdated assumptions than in evidence, is precisely the type of misconception we are here to address. As we consider the future of arbitration, it is important to reflect on the system we are building for the next generation. To create a strong and lasting arbitration framework, we must invest in 3 key areas: developing talent, strengthening institutions, and building trust among stakeholders. Africa is not just hoping to become a global hub for arbitration, it is already on that path. It is our duty to ensure that this development is built on strong values of excellence, integrity, diversity, and inclusion. We are moved beyond the question of whether Africa can arbitrate. The focus now is on demonstrating the quality and effectiveness of arbitration across the continent. Our responsibility is to amplify these achievements, support our institutions, and demand the recognition and trust our systems deserve. Africa has capable arbitrators, competent institutions, and stories of success that deserve the global stage. These stories must be documented, shared, and celebrated. As I conclude, I commend the organizers and all participants for contributing to this important conference. Let us continue to uncover and elevate Africa's untold stories, not only in arbitration, but also in law, governance, and leadership. It is time for Africa to move from the margins to the center of the global arbitration narrative with confidence, clarity, and commitment. Lastly, to our guests, I welcome you to Kigali, the capital of Rwanda, and wish you all productive discussions and successful outcomes from this conference. Thank you.
Thank you so much, our chief guest, for the kind remarks. The next item on the agenda, as I requested, that the first 2 rows join our chief guest and the members of the panel here for a group photo. Please, may you approach. We're going to stand behind here. Please.
Thank you. Thank you. My chairman. Did you introduce my chairman?
Yeah, and congratulations. Thank you for all you are doing.
Thank you so much. Thank you. As you're getting to your seats, yes, for other photo sessions, we have a booth in front there. We're going to have many opportunities to take more photos. And for now, it's my pleasure to invite the Honorable Minister of Justice and the Attorney General of the Republic of Rwanda to give us a keynote remarks. Honorable Minister of Justice, Dr. Emmanuel Ugiasebuje, the floor is yours. Thank you so much. You're welcome.
So let me first of all abide by the directions of Her Ladyship, the Chief Justice, when she directed how the protocols should be. So I don't want to repeat because she has already directed. And I hope we will follow that order in order to save time. But Your Ladyship, allow me only on the list that you mentioned to mention one other person, and that's my brother who we lived with in Arusha, Professor Niungeko, the President Emeritus of the African Court on Human and People's Rights. So you are welcome to Rwanda, and all the others who are mentioned are welcome to Rwanda. It is an honor to stand before you today at this ICCA KIAC conference, a gathering that underscores Africa's growing prominence in the field of international arbitration. As we convene in Kigali today, we recognize not only the continent's evolving arbitration landscape, but also Rwanda's emergence as a key player in shaping its future. So we recognize what KIAC has been doing, and we are proud of what KIAC has been doing. Also, the other centers that are present today, you make Africa proud. Of course, we all know that Africa's arbitration framework has undergone significant transformation over the past years. Historically, arbitration was often conducted outside the continent, with disputes involving African parties resolved in London, Paris, or Geneva. However, today Africa is witnessing a shift towards African arbitration hubs, driven by legal reforms, of course, that have taken place, institutional development, and political commitment. And I want to commend all of you in this room, because I know most of you, and I know the role that you've played towards this particular shift that we are seeing today, and we hope that you'll continue in this journey. Several African nations have modernized their arbitration laws, aligning them with international standards such as the ancestral model law. I do recognize institutions which are here today, such as the Cairo Regional Center for International Commercial Arbitration, the Lagos Court of Arbitration, of course our own KIAC, the nascent arbitration centers in Tanzania and also Zambia, which have strengthened Africa's arbitration infrastructure. Additionally, we can all be happy of what has been done in the OHADA region, where the OHADA Uniform Arbitration Act is applicable in 17 West and Central African countries. And this provides a harmonized legal framework that enhances arbitration accessibility and efficiency. So Dr. Gaston, thank you for what you've done in this particular region. However, despite these advancements, challenges still remain, as the Chief Justice has pointed out. Some African jurisdictions still grapple with judicial interference. We have to be frank about this if we want to advance arbitration. At times there are enforcement difficulties, and there's also sometimes limited awareness of arbitration's benefits. Not everyone still understands the benefits of arbitration, and it's something we need to work towards too. However, the continent's political stance is increasingly supportive, with governments recognizing arbitration as a key tool for economic growth, investment protection, and dispute resolution. Of course, we witnessed this shift because of this particular political will, and this is actually demonstrated by the presence of an Attorney General who traveled to Rwanda, not for bilateral meetings, but to attend this conference. My brother, the Attorney General of the Republic of Malawi, you're welcome. And I know many others would have loved to be with us today, showing that they have this political will towards advancing arbitration in Africa. As the host country for this prestigious conference, Rwanda exemplifies Africa's commitment to arbitration. The Kigali International Arbitration Center, which was established in 2012, has positioned Rwanda as a preferred arbitration seat in Africa and in the whole world. We do reckon that a lot of you here played an important role in KIAC's modern rules, its neutrality and efficiency, and especially those who are on the roster of KIAC as arbitrators. You've done proud, and you've encouraged KIAC to continue in the right direction, and I really want to thank you all. And this has led to attraction of both domestic and international disputes, reinforcing Rwanda's reputation as an arbitration-friendly jurisdiction. Here in Rwanda, legal framework is aligned with international best practices, and KIAC, as well as all the other institutions, have ensured that there is independence, enforceability, and procedural fairness. The government of Rwanda pro-business policies and investment-friendly environment further enhances arbitration's appeal. Rwanda's judiciary, and I've seen the 3 chief justices who have headed the judiciary here in the room, have also demonstrated a strong support for arbitration, and they've encouraged minimization of court intervention and upholding arbitral awards. So we are very proud of what you've done, the 3 chief justices here today. As arbitration practitioners, policymakers, and stakeholders, we must continue strengthening Africa's arbitration ecosystem. We must promote awareness, enhance institutional capacity, and ensure arbitration remains a trusted mechanism for resolution of disputes. Rwanda's example demonstrates that with vision, commitment, and collaboration, Africa can lead the way in international arbitration. And of course, again, I want to stress that it has been an effort of all of you here in this room. Honorable guests, esteemed colleagues, and distinguished arbitration practitioners, there is no doubt that Africa is a continent that is rapidly emerging as a global economic powerhouse. This is evidenced by so many other elements that, of course, will be highlighted by the economists in the room. I can see Andrew here. I'm sure he'll try to show us why Africa is a global economic powerhouse. Arbitration is increasingly becoming an essential tool for resolving disputes. Today, I will highlight just a few key drivers that propel arbitration forward across Africa. There is, of course, increased confidence in investment and international trade here in Africa. Africa's growing economic confidence is a major catalyst for arbitration expansion. With the implementation of the AFCFTA, intra-Africa trade is expected to increase by different numbers, but the most recent statistic that I have is that it will increase by over 50% if we get everything right. This will reduce reliance on external markets. As businesses and investments engage in cross-border transactions, arbitration provides a neutral, efficient, and enforceable mechanism for resolving disputes. So it is up to us to try and craft an arbitration mechanism for the continent that will allow us to move forward as the other parts of the AFCFTA are implemented. And I do hope that we will have suggestions, proposals, and recommendations from this conference. African governments and private sector players are increasingly recognizing arbitration as a preferred dispute resolution method and ensuring that commercial disagreements do not hinder economic progress. This shift is fostering a business-friendly environment, and to an extent, some economists have said that it will continue, if we continue in this path, this will attract investment and strengthen Africa's position in global trade. It is also not disputed that Africa is home to 30% of the world's mineral reserves, including gold, diamonds, oil, and the rare earth elements. And the continent's vast natural wealth has led to large-scale investments in mining, energy, and infrastructure, often involving multinational cooperation. Arbitration plays a crucial role in resolving disputes in extractive industries, ensuring that contracts are honored and disputes are settled fairly. With the rise of resource nationalism, arbitration provides a balanced approach that protects both investors and host states, ensuring sustainable development while safeguarding national interests. Another driver is that Africa's economic growth is only second to, I believe, Asia. If I'm not wrong, the economists will correct me if I'm wrong. With several countries experiencing an annual GDP growth exceeding 5%. This rapid expansion is driving demand for efficient dispute resolution mechanisms as businesses seek to resolve conflicts without lengthy court battles. Arbitration offers, of course, a speedy, flexible, and it ensures confidentiality, making it the preferred choice for resolving commercial disputes. As African economies continue to grow, arbitration will play a pivotal role in maintaining stability and fostering investor confidence. Of course, another important driver is the role of the judiciary in supporting arbitration. We've seen a strong and independent judiciary being developed in Africa, essential for arbitration success. Across Africa, courts are increasingly upholding arbitral awards, minimizing judicial interference, and promoting arbitration-friendly policies. Almost all the countries represented here, we've seen movements towards this where the judiciary is actively supporting arbitration. Judicial training programs, as mentioned by, I think it's Professor Bosman here, and legal reforms are further strengthening arbitration credibility, ensuring that African courts recognize and enforce arbitral decisions in line with international standards. And generally speaking, most African states have made significant strides in embracing arbitration as a key mechanism for dispute resolution. Long are the days when some of the judiciaries used to consider arbitration awards as awards that can be appealed against when it came to setting aside. I don't think that there's any jurisdiction nowadays that does that. Well, it was as such a few years ago, but I think that's history. Many African nations have signed and ratified the Washington Convention on the Settlement of Investment Disputes between states and nationals of other states, enabling them to participate in investor-state dispute settlement under the ICCID. This enhances, of course, investor confidence. A vast majority of African states have adopted the New York Convention on the recognition and enforcement of foreign arbitral awards, ensuring that arbitration decisions are recognized and enforced across the borders. African governments have increasingly viewed arbitration as a catalyst for economic development. By promoting efficient dispute resolution, arbitration enhances investor confidence, reduces, of course, some costs when it comes to. We still do have some of us who prefer disputes settled outside the continent, and this reduces the trust in local arbitration. And here, I must point out the bigger burden goes to the attorneys general and the Bar Association, because when they draft the agreements or contracts, they have the opportunity to decide which arbitration center can be used. There are certain key trends that are shaping Africa's arbitration future, and I've discussed some of them, including growing preference for African arbitration seats. And we've seen some of the seats doing a fantastic job, most of which are here, and I don't want to mention any of them because I do recognize that all of you are playing an important role in ensuring that different arbitration seats in Africa or centers are gaining prominence. The AFCFTA, of course, is expected to increase intra-African trade, leading to a higher demand for arbitration. The question is, how are we crafting an arbitration for these particular purposes of dealing with disputes that may arise as the AFCFTA is widening and expanding in terms of its scope. Of course, we do expect that there will be more judicial support and legal reforms across Africa as we attempt to be even more arbitration friendly. Capacity building is key, as well as institutional strengthening of these centers that we have. I do believe that it is important in investing in training arbitrators, improving infrastructure, as well as enhancing procedural efficiency. Initiatives such as the SOAS Arbitration in Africa survey highlight the continent's growing expertise and commitment to arbitration excellence. I cannot complete my keynote without talking about the AI era. We are living in the AI era, and it has potential of transforming arbitration, making dispute resolution potentially faster, more efficient, and data-driven. Here are some of the key trends shaping the future of arbitration in the age of AI. And the first trend is that we may witness AI-powered case management as we are beginning to see this happening in the judiciaries across Africa. Artificial intelligence can streamline arbitration by automating documents, reviewing the documents, case analysis, as well as procedural tasks. This may reduce the costs and speed up dispute resolution, making arbitration more accessible. So I ask all of us to try and embrace AI, where it will make procedures much more faster and cost efficient. The second trend is that of predictive analytics in decision making. AI can analyze past arbitration awards and predict possible outcomes, sometimes helping parties to assess risks and make informed decisions before they proceed with arbitration. This is a possibility that is there when you look at what AI is doing, especially in different judiciaries across the world. There are some commentators who are even much more forward-looking when they discuss about AI, and there's a discussion about AI-assisted arbitrators. While I'm not as optimistic as those other commentators, I do believe that AI is unlikely to replace human arbitrators entirely. It can assist in, at times, drafting awards, analyzing evidence, and ensuring consistency in ruling. However, I don't believe that we are in that era where we will have AI arbitrators. Some of the commentators, such as the Justice retired Gupta of India, believes that there are certain arbitration cases that can be handled by AI, small arbitrations as he refers to them. The other trend is online dispute resolution. I do believe that Kimei will mention this. I've heard you talking about this, but it's a reality. And we do believe that AI-driven ODR platforms are gaining traction, at least allowing parties to resolve disputes remotely. And this is particularly useful for cross-border arbitration and reducing logistical challenges. As we discuss AI, it's important to look at the ethical and legal challenges when it comes to the use of AI, both in our judiciaries as well as in arbitration. Despite all its benefits, AI in arbitration raises concerns about bias, transparency, and accountability. And I do commend institutions such as SIAB and Wahabia for actually being at the forefront of developing guidelines to ensure AI is used responsibly. And I've seen that you've developed SIAB guidelines on the use of AI in arbitration, which is a 2025 document. So we commend you for this. You are forward-looking, and we do hope that you'll continue monitoring what is happening in this space so that we can ensure that there's ethical and legal considerations as we use AI. The future of arbitration in Africa is certainly bright, with local institutions, legal reforms, and regional integration driving this growth. By embracing African-led solutions, the continent is positioning itself as a global arbitration powerhouse, which ensures fairness, efficiency, and at times culturally relevant dispute resolution. However, I want to pose this question. What will it take for Africa arbitrators and institutions to truly sow and reap the fruits of the bright future of arbitration in Africa? So this is a question that I want to pose to all of you as you consider the different topics today. For arbitrators, and I want to particularly address young arbitrators, the ability to succeed in the world of arbitration will rely heavily on persistence, resilience, and adaptability. And I do believe the senior arbitrators here will tell you this. It was not a walk in the path during their journey towards where they are. Success in arbitration cannot come on a silver platter. You have to work for it. No plan unfolds exactly as expected, and obstacles are inevitable. Many people, and at times institutions, tend to give up when faced with setbacks, seeing them as failures rather than as opportunities to reassess and adjust. Strategic thinkers and actors embrace setbacks as a natural part of the process of growth. And I do hope that we will think about arbitration in Africa in a strategic manner so that we can embrace any setbacks that we meet in our journey towards achieving what we have set ourselves for. The world is in constant flux. Markets are shifting, technologies are evolving at a breathtaking speed, and the unexpected has become a daily reality today. In such a dynamic environment, strategic adaptability is not just a desirable trait, it is a survival skill for arbitration practitioners. And those who will try to cling to outdated methods and who will refuse to evolve with changing circumstances will eventually find themselves obsolete, outpaced, and at times outmaneuvered. On the other hand, those who will develop adaptability, the ability to reassess and execute new approaches without losing sight of long-term objectives, will gain an undeniable competitive advantage. Many failures occur not due to lack of intelligence or effort, but because people fail to recognize the warning signs of change early enough. Successful arbitrators and institutions cultivate acute awareness, constantly monitoring trends, staying informed about emerging developments, and analyzing their potential impact. They do not wait for disruption to force their hand. They anticipate it a bit early and recognize that change allows for proactive adaptation rather than reactive damage control. Having reviewed the conference program, I am confident that this gathering will serve as a platform for cooperation, collaboration, constructive debate, and effective exchange of ideas to advance arbitration in Africa. It is my sincere hope that by telling the untold stories of Africa and international arbitration, you, our esteemed arbitration practitioners, will design frameworks to sustain arbitration success in Africa, that you will leave behind a true legacy by creating new paradigms that challenge conventional wisdom in how arbitration is practiced and redefined, and try to redefine what is possible for arbitration in practice in Africa. The future of arbitration in Africa will be shaped by those of us who dare to think ahead, act decisively, and build something greater than ourselves. So we hope that telling the untold stories will not be an end in itself. We have to act decisively after we've heard the stories and build something greater than ourselves. For those of us passionate about the future of arbitration in Africa, one main question remains: what will be the legacy of this ICCA KIAC 2025 conference for Africa? What legacy will you leave beyond these 2 days of this conference? And I hope that tomorrow we'll get the answer after having heard what you will present. And we are all excited about the panels that will follow this keynote and the panels tomorrow. Africa stands at the forefront of arbitration global evolution, and with increased confidence in investment, our natural resources, rapid economic growth, and judicial support, arbitration is becoming the preferred dispute resolution mechanism across the continent. But at times when we are discussing this, and in many conferences that we've been to, you do feel that we are arbitration in Africa, and the discussion that we have, it is like we are on a runway, and the longer you stay on a runway without taking off, it becomes calamitous. So we do hope that this is an opportunity to take off, because the opportunities are there. We only need to seize these opportunities. So let's seize these opportunities that are here, that are visible, to shape the future of arbitration in Africa. Before I conclude, let me, as the host, and the Chief Justice has done that, let me reiterate what the Chief Justice said. You are very welcome to Rwanda. If you do wish to have ICCA 2026 in Rwanda, please feel free to also do that. But for some of you who have extra time, you can take a day or two to visit Rwanda pay a visit to other parts of Rwanda. And I can assure you that there are certain parts of Rwanda, if you visit, you will certainly reconcile with any parts of you which you have conflict with. Thank you very much, and I do hope that you have a successful conference.
Wow. Thank you so much, Honorable Minister of Justice and the Attorney General, for very informative keynote address. He has taught us, he has informed us, he has questioned us, and what I hear from it is that we need to adapt. So at this juncture, you may allow our chief guest, the Right Honorable Chief Justice, to take her leave, and before I invite our first panel to take their seats. Thank you so much. Yes, as our chief guest is taking her leave, may I invite our first panel, Professor Mohamed Abdel Wahab, who will be our moderator, Ms. Nakasamba Banda Madeleine Kimei, Abayomi Okuboti, Naomi Tarawadli. Please take a seat. Thank you. You're welcome.
So good morning, good day. It's a privilege to stand before you. I'm very grateful for the invitation, and I'm so delighted that we're all here in Kigali, Rwanda. We are privileged, of course, to have been addressed by the Right Honorable Chief Justice and the Minister of Justice and Attorney General. And I think they've addressed us on a number of themes that will feature prominently in our first panel. I'm honored to moderate this panel. Let me tell you how it's going to go by. So we're addressing legal reforms, the untold stories. And the theme of the event itself, speaking of untold stories, reminds me of a 2016 movie called The Untold Story. It's starting over is never too easy. Now, fortunately, we don't need to start over in Africa. We need to build on the work that has been done. But the theme of that movie back in 2016, the themes, I would say, revolve around resilience, finding purpose, forging meaningful connections, and ultimately achieving success. And the panel today, hopefully we intend to do nothing but be candid, controversial, and hopefully share some enriching insights through the star panelists that I will present in a minute. The way and the format we intend to run this is going to be a discussion over some set themes and topics. We'll start with setting the stage, few slides in the backgrounds, sharing where we stand and what we term relics of colonialism. And then we'll move to address why legal reform is relevant for Africa and investors. Thirdly, we're going to touch on whether and to what extent legal reform has been successful. If so, why? If not, how and why did not happen, and what can be done, sharing some untold stories. Then we'll move on to address a theme that His Excellency, the Minister of Justice and the Attorney General of Rwanda has touched upon, which is part of our candid discussion, government intervention, judicial protectionism, in relation to disputes and arbitrations involving state and state-owned entities on the continent, and share some thoughts on conceptions and misconceptions. And then finally, to conclude, whether Africa and African practitioners are ready in terms of being arbitrators, counsel, users, and institutions. So we have a discussion around those themes with each panelist taking the lead and others sharing comments within the time we have. Then hopefully we'll have some time at the end for a Q&A where you can share your thoughts, comments, and questions. Now let me first introduce the panelists. that we have today. And let me start with the ladies. And in the order they are seated, Naomi Tarawali is a partner with Cleary Gottlieb in London. She has represented corporates and high net worth individuals and entities in arbitrations under major institutional rules. She handles complex litigation as well. And she actually has been described by a number of directories, including Legal 500, Who's Who Legal, as a rising star and a future leader in the space. She is also featured in the top 30 power list for Africa by the Africa Arbitration Academy for rising practitioners. Naomi, you're welcome, and glad to have you with us. Next in order is Madeline Keme from Tanzania. Madeline is the founder of iResolve in Tanzania, which offers state-of-the-art solutions in law and technology aspects. She is also the president of the Tanzanian Institute of Arbitrators, and she is an ex-member of the International Court of Arbitration by the ICC, and currently a member of the court at KIAC. Also listed in directories and known to be, again, one of the very important practitioners in Tanzania and on the continent. Welcome, Madeline. Glad to have you with us. We have Nakasamba Banda from Zambia. Nakasamba, as well, is a prominent practitioner in Zambia. She is a partner with AMW & Co. Advocates. She is the inaugural Secretary General of the Lusaka International Arbitration Center, the chair of the Zambia branch for the Chartered Institute of Arbitrators. She is both an arbitrator and counsel and has done sort of adjudication and mediation as well. She is a member of Young AFSA, Young ICCA, and member of the International Arbitration Committee of the IBA and ARB40. Delighted to have you, Nakasamba, with us. And then finally, Abayomi Okubuti, who is actually a professor, well, he's dual qualified in Ontario and in Nigeria. He is a professor of international business law in Canada and the executive director of the Africa Arbitration Academy, which I think is known to all of us globally, and the mastermind behind the academy, along the seven magnificent, as I call them. And so he's also sat as arbitrator and acted as counsel under ICC, LCA, and UNCTAD arbitration rules, and sat as arbitrator in a number of domestic and cross-border disputes across Africa. And he again features in directories prominently as a thought leader and a future leader and partner in that sense, where he also is a partner with Pinsbury Advocates as well. So you see, we have star practitioners, promising young African faces. Although they remain young, but they also have the knowledge and the wisdom to share with us today. So let me start by inviting Abayomi to address us, and I think we have some slides where we will start by setting the stage. Abayomi, the floor is yours. Thank you.
Thank you very much. Good morning, everyone. So it's difficult to be moderated by an erudite professor, Professor Abdul Wahab. Thank you very much for that kind introduction. So what I will do in the next 3 to 5 minutes is to quickly walk us through some of the key reforms, institutional shifts, and regional trends that are shaping disputes generally in Africa. And I invite you all to follow the slides on the screen. Yes, can you confirm that you can see my screen? As you can see the screen? Yes, excellent. So in the last 10 years, as you can see from the screen, about 10 countries have either amended or introduced new arbitration laws in different countries in Africa. We have Uganda, Malawi, Nigeria, Sierra Leone, Morocco, Tanzania, the Uniform Act of Arbitration applicable in 17 Francophone countries, and also in South Africa. Now, one thing to note is that these amendments are not just cosmetic. They were done largely to align the laws in these countries with the ancestral model law to enhance enforceability of awards in those jurisdictions and to generally make those jurisdictions attractive for dispute resolution. For example, in Nigeria, we have the 2023 Arbitration and Mediation Act, which aligns the laws in Nigeria with the 2006 ancestral model law, and has important provisions including third-party funding, expedited arbitration, interim measures in support of arbitration, and a number of important provisions. Some of these provisions are now being tested. For example, recently, in the case of Dalot East Africa Limited against Rwanda Revenue Authority, a case that happened here in Kigali, and it was seated in Kigali under the auspices of KIAC, and that case was the enforcement in that case was sought to be funded by a third-party funder. So, counsel in that case was able to convince the funder that there is a permissive statutory framework for third-party funding in Nigeria, and it was on that basis that that case was funded. So we have other countries like Malawi, like Uganda, like Sierra Leone. Sierra Leone and Malawi are actually important because they've introduced institutional reforms. What you have in Malawi today is that the applicable law has introduced the establishment of the Malawi International Arbitration Center. We also have the establishment of the Sierra Leone International Arbitration Center, trying to improve institutional arbitration in those countries. So beyond the law reforms in these countries, what we have thought to do is also to look at judicial support for arbitration, because it's not enough to have good laws. Laws may be good on the paper, but how are these laws being interpreted? So we've looked at these jurisdictions to see, prior to the law reform, what was the disposition of the judiciary in support of arbitration? After the law reform, what was the disposition of the judiciary? So what I've done is to set out a number of criteria for assessing the disposition of the judiciary in those jurisdictions. So if, for example, in Nigeria, for example, has a strong support for arbitration. Courts have exercised pro-arbitration approach, especially after the recent Arbitration and Mediation Act. In Uganda also has a strong judiciary, generally respects arbitration agreement and enforces award. Even though the government in Uganda, some months ago, we had the Attorney General of Uganda join us during the Paris Arbitration Week. And what he said is that in Uganda today, government typically will not include arbitration agreements in their contract solely because of some of the bad experiences that they've had with arbitration. But that is not definitive of the whole legal system in Uganda. The judges in Uganda are generally supportive of arbitration. In Sierra Leone, we've rated it moderate because reform is quite recent, so judicial capacity is still improving based on the reform. Morocco is a very strong country in the MENA region, recognized as pro-arbitration. Tanzania, South Africa, and Uganda. Now, beyond the legal reforms and the support for arbitration, we've also looked at the perspectives of the users in these countries. We had a recent survey by the Africa Arbitration Academy on dispute resolution in Africa. And the survey tested a number of issues, asking questions from the perspective of the users. One thing that came out from that survey, first of all, is what are the considerations when negotiating dispute resolution clauses in Africa? And most of the survey respondents have said that enforceability of award is key. They're always concerned about enforcement of award. Some are also concerned about cost, setting precedent, confidentiality, time, neutrality, and quality outcome. For the duration of arbitration, what we thought to ask was, when you look at arbitration vis-a-vis litigation, what is the likely duration? What you see is that most survey respondents have said between 1 to 3 years. Arbitration is quite faster or more faster than litigation. We also have questions relating to what are the cost-saving measures for efficiency of African dispute. And most survey respondents have said the use of technology is very important, innovative funding structures, use of expedited proceedings, the use of document-only procedure, excluding discovery, and the use of online dispute resolution processes. At this juncture, we'll go granular to some other countries like Zambia and Tanzania, and I invite Madeline to speak on Tanzania.
Yes. So we can do that while seated. So just to give our audience the idea, Madeline has conducted a survey in Tanzania. So we're moving from a more macro into a micro level, looking at Tanzania and Zambia specifically. So Madeline, Tanzania, and then Nakasan will address Zambia.
Thank you, Professor, and thank you so much for this welcome to this panel this morning and the moderation so far. Thank you, Dr. Abayomi, for setting out the stage in terms of Africa and looking at Africa and what has been done to get us to the pace that the minister has just spoken of in terms of catching up, and not only catching up, but leapfrogging and getting to a stage where we are all in a comfort zone of some sort. We heard the runway word, that we're still in the runway. We wouldn't want to be on a runway for too long. And so, yes, I did conduct a survey this particular year. This is, I think, the first survey in Tanzania that focused on usage of alternative dispute resolution in Tanzania by businesses. The survey ran in March 2025 and concluded in April 2025. Now, it was a very small survey due to the number of respondents that took time to take the survey. And so we had only 60 respondents. However, despite the fact that it was a small number of responders, I think it speaks volumes in terms of data, the actual reality, not only in Tanzania, but also on the continent at large, in terms of, one, the barriers of using alternative dispute resolution, including arbitration in that formula or in that spectrum aspect. Now, the barriers, as you can see there on the slide, and hopefully I can be assisted with the slide. And this is, I think, the third slide from Abayomi's slide. While they work on putting up the slide for me, what it says there is that about 52% of those responders say that the barriers to using arbitration in ADR were costliness and complexity of the process itself. That connects the dots to the numbers that you will see projected in front of you in terms of the methods, the levels of use of the mechanisms, including arbitration. And when they were asked about the level of usage and involvement in ADR, what they said was about 26% of them pretty much had
none at all experience or no knowledge of any such mechanisms. And only 6%, I won't go through all the data, but the 6% is the blue there on the first circle. The blue, the dark blue, 6% indicated that they had a great deal of experience or involvement in ADR. So it speaks volumes, and it connects the dots to the barriers that they had put out at the initial stage of the survey. In terms of the methods used, we see 62% opting for negotiation. This is the most unformalistic ADR mechanism one can approach. And why is that the case, I asked myself. And the answer to that, and you will read in my report once it's out, end of June, is that we already have a culture that is not pro out-of-court sort of settlement. And so we've got litigation there getting a percentage of 39%, vis-a-vis the negotiation 62%. And so we have, we've come up from an English modeled jurisprudence, common law jurisprudence, very litigative communities. And so the negotiation element, what I find from the survey, is the aspect of the traditional forms that are being used on the ground. These are highly negotiative in manner of how they conduct these in the tribal settings. I'm from the Chaga tribe, just below the Mount Kilimanjaro, and what we use is the chiefdom sort of approach, where you go to the chief of that tribe, and it's a negotiation, really. And so the attraction to negotiation stems from that backdrop. Just to go down to the responses in terms of arbitrator competence, and I only have 2 minutes, so I want to conclude, and this data will be available to you. Very highly qualified stood at 22% only, and somewhat qualified at 48%. I think this, again, connects the dots to the data at hand, where the factors influencing the costs are experience, expertise, and complexity of the dispute or subject matter. So where you find that you don't have expertise, especially from a procedural aspect of running an arbitration, that will eat into your costs. And this is what we seem to see on the ground. Not seem, it's the reality, because now we have data. We had no data prior. As I said, this was the first of its kind, and hopefully it will keep growing to give us raw realities on the ground. Now, I think just to expand on what Dr. Abayomi had presented with regards to the new legislations that have come to the forefront. In Tanzania, we do have a new enactment. Now, where is that enactment? Why is it so important to us? Why, just before I give the floor to Nakasamba, it is because we initially had an archaic arbitration ordinance that was taking its roots from pre-independence of Tanzania. And so it came from the English arbitration ordinance of 1887. And we had that running the test of time from 1932, when it became an enactment under Chapter 15 of the laws of Tanzania. It ran its ground until 2020. It had very minor changes in 1971, and in 1957, if I go back, I think there were rules to assist the courts in arbitration matters, and then we saw nothing for centuries, for decades. And so we were working with a very ancient enactment that was really picked up by the pro-judiciary approach that was being seen in the case law and the precedents that was coming from the courts. And so throughout that journey, the judiciary is what really kept us to pace with international standards in arbitration. Thank you.
Thank you. Nakasamba?
Is it coming back? Right. So when we talk about the African story, I think there's two issues that you must highlight, and you really can't tell the African story without recognizing, for instance, the relics of colonialism, because that is essentially what has brought about the current landscape. And secondly, you can't ignore the misconceptions and the perceptions that haunt us as an African continent. And I think this particular panel today basically seeks to bridge that gap between these misconceptions and the actual realities that are on the ground. And I think if you're on a panel with Prof, you know that you can't have you can't have a discussion without empirical evidence, right? He's the king of statistics. And I think that empirical evidence is important, especially if you wish to dispel a certain falsehood, or you want to figure out the way to move forward in terms of what you're doing right or wrong. But I think the challenge that we have as a continent, and specifically with regards to Zambia, where I come from, is that there just are no records that provide for these statistics. So we're sort of shooting blind. And I recognized this when we were preparing for this conference, because I literally could not find any statistics that I could bring forward and say, this is what's happening. I believe even in the case of Madeline, she literally had to undertake the statistics back in March. But regardless of that, I think there is still certain truths that can't be denied, and these provide the paradigm through which we can have those discussions. So I will give the Southern African context, and specifically with regards to Zambia, because I think Africa has been sort of provided holistically, and you've heard about Tanzania. So basically, Zambia is in Southern Africa, in case you are not aware. We're a landlocked country and have about 8 neighboring countries. Like every other African country, we were colonized, in this case by the British. But if you look at the SADC, which is Southern African Development Community, we have about 15 members. And just from those 15, you find that we have at least 6 different legal frameworks. So you've got the English system, you've got the French, you've got Portuguese, you've got the Roman Dutch, which would be South Africa. And because of this, obviously, it leads to the perception of complexities in arbitrating in Africa, because you've got that legal pluralism, right, as a start. With regards to Zambia specifically, we are a signatory of the New York Convention, and I believe in Africa holistically, there's like 42 out of 54 that have signed on to the New York Convention. So obviously issues of enforcement are not necessarily of concern, but we will address this further later. In terms of our laws, just like Tanzania, I think we're now getting into our 3rd generation laws. And by generation, I think the 1st generation laws are the ones we consider pre-colonialism. So our first Arbitration Act was 1933. We only got independent in 1964, and our 2nd generation law, which would essentially try to modernize and was based on the model law, was in 2000. And we're currently reviewing the laws, so we are now we're getting into our 3rd generation law, which is essentially what is happening with most of the African countries that have been listed by Abayomi. With regards to, perhaps the slide could now be put back. Okay, so with regards to the available statistics that were there, these were from the courts. And this only relates to mediation. And I think this is relevant because when you look at our laws, we only have court annex mediation that is sort of embedded in our high court procedure, where when you commence an action, it's then automatically transferred to mediation to attempt a settlement. But even before this institutionalization of ADR, I think traditionally mediation came naturally to us as Africans. This is how we resolved disputes. And I think that's why, usually when we talk of ADR, we don't say alternative dispute resolution. I think the common phrase these days is African dispute resolution, because that's really what we know. You know, you have to settle disputes out of court. So the statistics essentially are, the circle is by sector, and if you look at the largest sector, which is the blue, that would be the labor matters. And this is because with our labor division, it's automatic. Immediately you commence an action, it's then sent to mediation. I think the second in line there in dark blue was the commercial disputes, family disputes, and then finally you've got, I'm sorry, I can't see the last one.
Law in Canada, and the executive director of the Africa Arbitration Academy, which I think is known to all of us globally, and the mastermind behind the academy, along the seven magnificent, as I call them. And so he's also sat as arbitrator and acted as counsel under ICC, LCA, and UNCTAD arbitration rules, and sat as arbitrator in a number of domestic and cross-border disputes across Africa. And he again features in directories prominently as a thought leader and a future leader and partner in that sense, where he also is a partner with Pinsbury Advocates as well. So you see, we have star practitioners, promising young African faces. Although they remain young, but they also have the knowledge and the wisdom to share with us today. So let me start by inviting Abayomi to address us, and I think we have some slides where we will start by setting the stage. Abayomi, the floor is yours. Thank you.
Thank you very much. Good morning, everyone. So it's difficult to be moderated by an erudite professor, Professor Abdul Wahab. Thank you very much for that the kind introduction. So what I will do in the next 3 to 5 minutes is to quickly walk us through some of the key reforms, institutional shifts, and regional trends that are shaping disputes generally in Africa. And I invite you all to follow the slides on the screen. Yes, can you confirm that you can see my screen? As you can see the screen? Yes, excellent. So in the last 10 years, as you can see from the screen, about 10 countries have either amended or introduced new arbitration laws in different countries in Africa. We have Uganda, Malawi, Nigeria, Sierra Leone, Morocco, Tanzania, the Uniform Act of Arbitration applicable in 17 Francophone countries, and also in South Africa. Now, one thing to note is that these amendments are not just cosmetic. They were done largely to align the laws in these countries with the UNCTAD model law to enhance enforceability of awards in those jurisdictions and to generally make those jurisdictions attractive for dispute resolution. For example, in Nigeria, we have the 2023 Arbitration and Mediation Act, which aligns the laws in Nigeria with the 2006 UNCTAD model law, and has important provisions including third-party funding, expedited arbitration, interim measures in support of arbitration, and a number of important provisions. Some of these provisions are now being tested. For example, recently, in the case of Dalot East Africa Limited against Rwanda Revenue Authority, a case that happened here in Kigali, and it was seated in Kigali under the auspices of KIAC. And that case was, the enforcement in that case was sought to be funded by a third-party funder. So counsel in that case was able to convince the funder that there is a permissive statutory framework for third-party funding in Nigeria, and it was on that basis that that case was funded. So we have other countries like Malawi, like Uganda, like Sierra Leone. Sierra Leone and Malawi are actually important because they've introduced institutional reforms what you have in Malawi today is that the applicable law has introduced the establishment of the Malawi International Arbitration Center. We also have the establishment of the Sierra Leone International Arbitration Center, trying to improve institutional arbitration in those countries. So beyond the law reforms in these countries, what we have thought to do is also to look at judicial support for arbitration, because it's not enough to have good laws. Laws may be good on the paper, but how are these laws being interpreted? So we've looked at these jurisdictions to see, prior to the law reform, what was the disposition of the judiciary in support of arbitration. After the law reform, what was the disposition of the judiciary? So what I've done is to look, set out a number of criteria for assessing the disposition of the judiciary in those jurisdictions. So if, for example, in Nigeria, for example, has a strong support for arbitration. Courts have exercised pro-arbitration approach, especially after the recent Arbitration and Mediation Act. In Uganda, Uganda also has a strong judiciary, generally respects arbitration agreement and enforces award. Even though the government in Uganda, some months ago, we had the Attorney General of Uganda join us during the Paris Arbitration Week. And what he said is that in Uganda today, government typically will not include arbitration agreements in their contract solely because of some of the bad experiences that they've had with arbitration. But that is not definitive of the old legal system in Uganda. The judges in Uganda are generally supportive of arbitration. In Sierra Leone, we've rated it moderate because reform is quite recent, so judicial capacity is still improving based on the reform. Morocco is a very strong country in the MENA region, recognized as pro-arbitration. Tanzania, South Africa, and Uganda. Now, beyond the legal reforms and the support for arbitration, we've also looked at the perspectives of the users in these countries. We had a recent survey by the Africa Arbitration Academy on dispute resolution in Africa. And the survey tested a number of issues, asking questions from the perspective of the users. One thing that came out from that survey, first of all, is what are the considerations when negotiating dispute resolution clauses in Africa? And most of the survey respondents have said that enforceability of award is key. They're always concerned about enforcement of award. Some are also concerned about cost, setting precedent, confidentiality, time, neutrality, and quality outcome. For the duration of arbitration, what we thought to ask was, when you look at arbitration vis-a-vis litigation, what is the likely duration? What you see is that most survey respondents have said between 1 to 3 years. Arbitration is quite faster or more faster than litigation. We also have questions relating to what are the cost-saving measures for efficiency of African dispute. And most survey respondents have said the use of technology is very important, innovative funding structures, use of expedited proceedings, the use of document-only procedure, excluding discovery, and the use of online dispute resolution processes. At this juncture, we'll go granular to some other countries like Zambia and Tanzania, and I invite Madeline to speak on Tanzania.
Yes. So we can do that while seated. So just to give our audience the idea, Madeline has conducted a survey in Tanzania. So we're moving from a more macro into a micro level, looking at Tanzania and Zambia specifically. So Madeline, Tanzania, and then Nakasan will address Zambia.
Thank you, Professor, and thank you so much for this welcome to this panel this morning and the moderation so far. Thank you, Dr. Abayomi, for setting out the stage in terms of Africa and looking at Africa and what has been done to get us to the pace that the minister has just spoken of in terms of catching up, and not only catching up, but leapfrogging and getting to a stage where we are all in a comfort zone of some sort. We heard the runway word, that we're still in the runway. We wouldn't want to be on a runway for too long. And so, yes, I did conduct a survey this particular year. This is, I think, the first survey in Tanzania that focused on usage of alternative dispute resolution in Tanzania by businesses. The survey ran in March 2025 and concluded in April 2025. Now, it was a very small survey due to the number of respondents that took time to take the survey. And so we had only 60 respondents. However, despite the fact that it was a small number of responders, I think it speaks volumes in terms of data, the actual reality, not only in Tanzania, but also on the continent at large, in terms of, one, the barriers of using alternative dispute resolution, including arbitration in that formula or in that spectrum aspect. Now, the barriers, as you can see there on the slide, and hopefully I can be assisted with the slide. And this is, I think, the third slide from Abayomi's slide. While they work on putting up the slide for me, what it says there is that about 52% of those responders say that the barriers to using arbitration and ADR were costliness and complexity of the process itself. That connects the dots to the numbers that you will see projected in front of you in terms of the methods, the levels of use of the mechanisms, including arbitration. And when they were asked about the level of usage and involvement in ADR, what they said was about 26% of them pretty much had none at all experience or no knowledge of any such mechanisms. And only 6%, I won't go through all the data, but the 6% is the blue there on the first circle, the blue, the dark blue. 6% indicated that they had a great deal of experience or involvement in ADR. So it speaks volumes and it connects the dots to the barriers that they had put out at the initial stage of the survey. In terms of the methods used, we see 62% opting for negotiation. This is the most unformalistic ADR mechanism one can approach. And why is that the case, I asked myself. And the answer to that, and you will read in my report once it's out, end of June, is that we already have a culture that is not pro out-of-court sort of settlement. And so we've got litigation there getting a percentum of 39%, vis-a-vis the negotiation 62%. And so we have, we've come up from an English modeled jurisprudence, common law jurisprudence, very litigative communities. And so the negotiation element, what I find from the survey, is the aspect of the traditional forms that are being used on the ground. These are highly negotiative in manner of how they conduct these in the tribal settings. I'm from the Chaga tribe, just below the Mount Kilimanjaro, and what we use is the chiefdom sort of approach, where you go to the chief of that tribe, and it's a negotiation, really. And so the attraction to negotiation stems from that backdrop. Just to go down to the responses in terms of arbitrator competence, and I only have 2 minutes, so I want to conclude, and this data will be available to you. Very highly qualified stood at 22% only, and somewhat qualified at 48%. I think this, again connects the dots to the data at hand, where the factors influencing the costs are experience, expertise, and complexity of the dispute or subject matter. So where you find that you don't have expertise, especially from a procedural aspect of running an arbitration, that will eat into your costs. And this is what we seem to see on the ground. Not seem, it's the reality, because now we have data. We had no data prior. As I said, this was the first of its kind, and hopefully it will keep growing to give us raw realities on the ground. Now, I think just to expand on what Dr. Abayomi had presented with regards to the new legislations that have come to the forefront. In Tanzania, we do have a new enactment. Now, where is that enactment? Why is it so important to us? Why, just before I give the floor to Nakasamba, it is because we initially had an archaic arbitration ordinance that was taking its roots from pre-independence of Tanzania. And so it came from the English arbitration ordinance of 1887. And we had that running the test of time from 1932, when it became an enactment under Chapter 15 of the laws of Tanzania. It ran its ground until 2020. It had very minor changes in 1971 and in 1957, if I go back, I think there were rules to assist the courts in arbitration matters. And then we saw nothing for centuries, for decades. And so we were working with a very ancient enactment that was really picked up by the pro-judiciary approach that was being seen in the case law and the precedents that was coming from the courts. And so throughout that journey, the judiciary is what really kept us to pace with international standards in arbitration. Thank you.
Thank you. Nakasamba?
Is it coming back? Right. So when we talk about the African story, I think there's two issues that you must highlight, and you really can't tell the African story without recognizing, for instance, the relics of colonialism, because that is essentially what has brought about the current landscape. And secondly, you can't ignore the misconceptions and the perceptions that haunt us as an African continent. And I think this particular panel today basically seeks to bridge that gap between these misconceptions and the actual realities that are on the ground. And I think if you're on a panel with Prof, you know that you can't have you can't have a discussion without empirical evidence, right? He's the king of statistics. And I think that empirical evidence is important, especially if you wish to dispel a certain falsehood, or you want to figure out the way to move forward in terms of what you're doing right or wrong. But I think the challenge that we have as a continent, and specifically with regards to Zambia, where I come from, is that there just are no records that provide for these statistics. So we're sort of shooting blind. And I recognized this when we were preparing for this conference, because I literally could not find any statistics that I could bring forward and say, this is what's happening. I believe even in the case of Madeline, she literally had to undertake the statistics back in March. But regardless of that, I think there is still certain truths that can't be denied, and these provide the paradigm through which we can have these discussions. So I will give the Southern African context, and specifically with regards to Zambia, because I think Africa has been sort of provided holistically, and you've heard about Tanzania. So basically, Zambia is in Southern Africa, in case you are not aware. We're a landlocked country and have about 8 neighboring countries. Like every other African country, we were colonized, in this case by the British. But if you look at the SADC, which is Southern African Development Community, we have about 15 members. And just from those 15, you find that we have at least 6 different legal frameworks. So you've got the English system, you've got the French, you've got Portuguese, you've got the Roman Dutch, which would be South Africa. And because of this, obviously, it leads to the perception of complexities in arbitrating in Africa, because you've got that legal pluralism, right, as a start. With regards to Zambia specifically, we are a signatory of the New York Convention, and I believe in Africa holistically, there's like 42 out of 54 that have signed on to the New York Convention, so obviously issues of enforcement are not necessarily of concern, but we will address this further later. In terms of our laws, just like Tanzania, I think we're now getting into our 3rd generation laws. And by generation, I think the 1st generation laws are the ones we consider pre-colonialism. So our first Arbitration Act was 1933. We only got independent in 1964. And our 2nd generation law, which would essentially try to modernize and was based on the model law, was in 2000. And we're currently reviewing the laws, so we are now we're getting into our 3rd generation law, which is essentially what is happening with most of the African countries that have been listed by Abayomi. With regards to, perhaps the slide could now be put back. Okay, so with regards to the available statistics that were there, these were from the courts, and this only relates to mediation. And I think this is relevant because when you look at our laws, we only have court annex mediation that is sort of embedded in our high court procedure, where when you commence an action, it's then automatically transferred to mediation to attempt a settlement. But even before this institutionalization of ADR, I think traditionally mediation came naturally to us as Africans. This is how we resolved disputes. And I think that's why usually when we talk of ADR, we don't say alternative dispute resolution. I think the common phrase these days is African dispute resolution, because that's really what we know. You have to settle disputes out of court. So the statistics essentially are the circle is by sector, and if you look at the largest sector, which is the blue, that would be the labor matters. And this is because with our labor division, it's automatic. Immediately you commence an action, it's then sent to mediation. I think the second in line there in dark blue was the commercial disputes, family disputes, and then finally you've got, I'm sorry, I can't see the last one.
Industrial relations.
No, the green, the dark green. Well, I think ultimately you've got the industrial relations, the commercial disputes, and the family disputes, which are the bulk of the matters which are then sent to and resolved via mediation. On the right side, you have the mediations that are actually settled by location. And I think the location, this is the Lusaka registry, which is the capital, has got obviously the highest numbers because that's where most of the cases are commenced. But even in the other provinces, which are the more rural areas, you find that you have a lot of these mediation settlements. The red is really the amount of cases that have been resolved versus the amount of cases that were referred to arbitration. So you see that culture of settlement outside of the capital, showing that increased number of settlements that are actually resulting from that. So that's it on the mediation side. In terms of the arbitration side, I mean, honestly, there's literally very little statistics from that front, and this is simply because our arbitration is largely ad hoc, so there is nowhere where you actually have these statistics recorded. But we've recently established the Lusaka International Arbitration Center back in 2024, so, and we have now started commissioning a number of surveys, so I think in the next coming years, we will have a lot of data which will guide us in terms of our strategic follow-through. I think in terms of how this panel is going to go, it's important to sort of just highlight what these misconceptions are, and then we can then further discuss how, whether, you know, what the reality is on the ground. And I'll just highlight 4 of these perceptions that are there. The first one was obviously the legal framework, as I indicated. It's generally conceived as being fragmented, and this is really an issue that arises from the various legal systems that exist. We also have the perceived difficulties in enforcement of arbitral awards that we will look at. We also have the issue of judicial support that has been highlighted, the fact that there is this perception of judicial intervention and interference from the government. And then finally, I think there is a huge perception that there is a lack of local expertise on the continent. I think I'll stop there for now.
Thank you. So we're going to move directly because of time and we have a number of issues. Naomi, I think the issue now is why legal reform is relevant. And I think one of the misconceptions is that people think that legal reform is reduced to reforming arbitration-related legislation. But I think legal reform is much broader than that. So if you take the next few minutes to address us why that is relevant. Thank you.
Yeah, indeed. Thank you, Professor. Thank you, everyone. It's really great to... oh, it's working? Yeah. It's really great to be here. I'll speak a bit more directly, I think, is what I'm being told. Okay, hopefully you can all hear me now. So I'm going to address why is legal reform relevant? Why is it relevant for African states and for investors, particularly, to kick off our discussion? And let me start by saying I think there are many reasons why legal reform is relevant that have nothing to do really with investors. But I do think that is a very important piece of this, and we actually heard from our honorable guest this morning about the links between the commercial and economic factors already, and I'm grateful for those comments because they set the scene well. So who do we mean when we talk about investors? Well, there are, of course, people and businesses who choose to set up in their home African states, and that's wonderful. And then we have foreign investors who may come from other African jurisdictions, and I think in this room, at least, we've discussed before, wanting to see more of that kind of investment cross-border. And then there are foreign investors who come from outside of the continent altogether. My discussion will probably focus more on foreign investors in both of those categories. That's who I see more in my day-to-day practice. And I have 2 parts to my practice. So one is doing arbitrations and casework, but the other is advising on transactions. So I have transactional colleagues at my firm, and I spend a lot of time with them and with our investor clients discussing what their documents are going to look like and how they're going to structure their investments. And that's where I start to see the real importance of legal reform and legal reform on the continent for the investors, but also for the places in which they are investing. Personally, and it is a personal view, I think it puts it a little bit too highly to say, well, you know, if you have good legal reform, somebody who had no interest in investing somewhere will suddenly say, well, you've got a new Arbitration Act, I'll come and put some money there. And you know, I think that puts it a bit highly. But I do think it is a really important part of the package when investors are considering where, how much, what they are going to invest in. And that is a discussion that I am certainly seeing, and we're in the untold stories realm, so that's why I'm focusing on that. But I'm seeing that discussion happen more and more, and I would say in the last 3 to 5 years, much more than before that. And so legal reform really is a factor. And as I say, I don't think it's a determining factor of whether to invest or not, but it may well affect how much focus a business will give a particular jurisdiction. Why? Because, well, at the end of the day, they're looking at what's the return going to be. Investors, unlike arbitration lawyers, are not in the business of doing arbitration. They're in the business of making money. And there's, I think, increasingly a direct link and an appreciation of the link between the legal framework into which you invest and whether or not you may get your money back at the end of the day, or how much return you may be able to secure at the end of the day. And I see the investors having that conversation, being more willing to engage with the dispute resolution lawyers actually in having that conversation than previously. I'd like to see more data, so I don't know if my fellow panelists want to do more surveys. It might be interesting, but it could be that we're at a bit of an early stage. Abayomi's slide presenting the different reforms that have come in quite recent years. Maybe it's too early to see the impact of that on investment and the economic impact of that, but hopefully that will show, and it would be great to be able to track some of that. One other sort of untold story aspect to what I'm seeing and why I think this is important, we have some increasingly litigious firms. You've got sort of PE firms and hedge funds who part of their business now is looking for investment opportunities that involve disputes. So it's not only a case of investing in energy sectors or construction, the more sort of traditional areas, but also now there is a whole sector that revolves around investing in dispute resolution. And that's a piece that, from the state perspective, we want to make sure Africa is a part of that conversation and is well placed to be a part of that conversation and that growing sector. I would say the thing I get asked the most by our investor clients is, first, will the arbitration tribunal or will the court give me a remedy? So if my counterparty misbehaves or something goes wrong, am I going to get a remedy? And secondly, what can I then do with that? And this brings us to the enforcement question. Will I be able to enforce it? Will the courts respect this? Will they uphold it? Is the pathway to getting to enforcement certain enough? They really are focused on certainty. And so we get asked about reliable legal frameworks. We get asked about engaging counsel in the relevant jurisdictions. We get asked about enforcement and the robustness of the judiciary. And to your point, Professor, it's wider than reforming arbitration laws. The whole system needs to be geared up and supportive. And I think if we can start to answer those questions really positively and mentioning, the stories that are coming out of the continent, that I think will be an encouragement, and that I think will lead us to take off, as was mentioned earlier today. So if I can sort of conclude by answering the question directly, why is it relevant? Well, it's relevant because it has an impact for investors on the prospects of their return on investment. And from the state perspectives, it's relevant because it's a gateway to a route for investment. It's a gateway for sort of further investment in the country and promotion of the legal sector in the country. So hopefully that sets the stage for further discussion.
Thank you so much, Naomi. In a minute or so, if the other panelists wish to add to the point why it is relevant, we're going to come to the effectiveness of that. But part of this, since Naomi addressed us on investors, legal risk is one of the important factors when it comes to investment. And I wonder whether any of you have any thoughts to share as to the relevance that Naomi has outlined in terms of legal reform. So let me ask whether, Madeleine, you have anything you want to share in this space, or should we move on?
Professor, indeed, I do have a little to share with the participants and the panel with regards to the importance of legal reform. And in my understanding is that the efforts that came about after the reforms of the arbitration landscape in Tanzania, the aftermath of that is that there has been a wider awakening in application of the mechanism itself in the country. And we see that from the growth of the number of cases at the Tanzania Institute of Arbitrators, which deals much more with domestic matters. Now, we also see that from the numbers that the Office of the Solicitor General shared yesterday at their conference, and I noted his speech down. Our Solicitor General, Dr. Ali Possi, presented that the number of arbitration cases between July 2024 and April 2025 were about 209 matters, 180 being domestic and 29 being international. Now, we did not have such focusing in prior to the enactment, prior to the government's positive sort of approach to embracing these mechanisms, not only within the State Attorney's Office, the Attorney General's Office, but also on the domestic landscape. And so that brought about a lot of positive track record. I think from Naomi's presentation, I also noted her commentary on the fact that it is not a determining factor for investors. And we did see that in Tanzania's historical sort of journey from 2015, where we saw a lot of revamped legislation which was looking away from the ISDS system and more sort of natural resource protective measures being put up and closing the door to foreign arbitral tribunals. All these efforts came to be turned around at the wake of Mama Samia's government phase, where she then had to revisit these key legislative pieces, the Natural Resources Act, I won't mention all of them, the Unconscionable Terms Act, the Permanent Sovereignty, Unconscionable Terms Act, the PPP, which is the Public-Private Act. All these had to be revisited because of the difficulties in explaining that legal risk when we were negotiating contracts and on behalf of contracts. But it didn't have an impact if you look at the investment that was coming in. Although maybe it did. Sorry, let me track back, because I heard our Tanzania Investment Center director, a friend of mine, Gilead Terry, say that the volume of investments have a triple effect from the instant where the legislative pieces were circled back 360 to a model that was much more friendlier to the foreign eye or to the foreign investor, and also to the domestic players. So thank you.
Thank you. Before going to Nakasamba, because you'll be leading on the other topic, let me ask Abayomi if he has some thoughts on why legal reform is relevant.
Thank you very much. Can you hear me? Thank you very much, Prof. So we've been invited to be factual, and based on my experience, I think one thing to add is that legal reform, a number of times, is just a reaction to government of different countries either trying to seek loans or funding from donor agencies or financial institutions, and they are compelled in a way to establish this legal reform. For example, I recently worked with an African government where they were trying to get a loan from the World Bank, and the World Bank had included in the checklist for the requirement for the loan that the country should ratify the New York Convention and also modernize the arbitration law. So it's turned to a marathon or a relay for us to be able to, because the country needed the money so quickly, for us to be able to accomplish, coming up with a draft bill to modernize their law and to domesticate the New York Convention in that country. So a number of times, the legal reform is just a reaction to circumstances or when African governments are trying to seek funding or loans from international institutions. Also, legal reform sometimes is also to reduce dependence on foreign courts and jurisdictions. Why is that important? If there's no legal reform, parties will likely choose or default jurisdictions like Paris or London or New York, and the AG referred to this in his address. So legal reform is to increase capacity of local courts and local institutions. I had a discussion around this some days ago, and 2 cases were thrown at me by my colleague that I had that discussion with. They said, well, there's legal reform in Nigeria. How come Nigerian courts have come up with these two cases? The first case is the case of Limak and Salian. Some people here may be familiar with that case. That was a case that the Nigerian court had held that the Nigerian court had the jurisdiction to set aside a foreign arbitral award, an award from a foreign seat. So the person asked me, well, there's legal reform in Nigeria. How come Nigerian courts are having this kind of discussions or this kind of decisions? The second decision is Bayshore. Bayshore is a recent decision where a high court in Lagos, a high court in Nigeria actually set aside a procedural order. We classified that procedural order as an interim award and brought it for review under Section 55 of the Arbitration Act in Nigeria. Those are the two cases that people will always throw at us that, well, there's legal reforms in Nigeria. How come courts in Nigeria are still struggling with some cases like this? But that is not definitive of the judiciary in Nigeria. The judiciary in Nigeria is quite knowledgeable. So legal reforms a number of times is to increase capacity of local judges or institutions. I know in Nigeria today we have institutions like KIAC, AFSA, or COSICA that are largely now, or they have the capacity to take complex cases.
Thank you so much, Abayomi. That's very helpful. Nakasamba, any thoughts to share before we go to the next point?
Yeah, just a quick one on the necessity of legal reform. I read in a report of the Journal of Law and Economics back in 2021 that essentially provided like a case study of a particular country following their signature to the New York Convention. Foreign direct investment essentially increased by 10% within 4 years. So that is essentially empirical evidence showing you the relevance of legal reform and its necessity. I mean, we can sit here and talk about, the legal reforms that we're undertaking in Africa, but ultimately, money talks. And it's only if FDI is coming in that, arbitrations will actually happen. So I think that's the relevance there.
That's very helpful. Now, let's be a little bit candid, and let me ask you this. I know we need to be faster in that, but has legal reform been effective or successful? Because one thing is to enact laws through parliaments or have them in place, but have that been effective? Is it successful? And how do you measure success and effectiveness of that?
I don't know if you can actually outrightly state that, this has been effective. Because I think effectiveness is really, it's a journey. It's not a destination. It's something that you have to keep doing. You're trying to build trust of, the investors and and the international community as to, your systems and all. So effectiveness perhaps can be seen through, as you've indicated, we enact all of these laws, but ultimately it's how are they being brought to life. And so maybe the case law around Africa would be helpful in sort of highlighting whether it's been effective. And I'll give an example of the Tanzanian case. I know that there's been a lot that has happened since that, the setting aside. This is, what was the case? That was Standard Chartered versus the Tanzania Energy Electric Supply Company, where it was an ICCCA arbitration, and for purposes of enforcement, the award was, basically they granted an injunction to prevent the enforcement of the award. And, obviously it sort of sheds a bad light in terms of the challenges of enforcement in Africa, but we also have seen an increasing number of cases awards being easily enforced, for instance, in Uganda, where, you have awards that are just, regardless of the value of the award and, the displeasure of the other party, this was easily enforced. And so you see that shift within the continent. Another important case, which I think brings out a lot of, whether legal reforms have been effective, is one case in Zambia. This is the RDA versus Stefanuti case. And it's, as usual, it's, we're not publicizing these positive awards that are, or judgments of the courts in terms of judicial support that are coming out of the continent. But I think these form part of the legislative reform and seeing whether or not it's actually effective. So in the Stefanity case, this is a case that involved the construction of a road, and essentially it was a 950 million contract, and I think about 18% of that contract had been completed. But the award essentially awarded about 560 million. And the thing is, in as much as we're trying to talk about effectiveness, we also need to self-introspect as to what we're doing wrong. So there's this growing tendency by legal practitioners to try and set aside, when they're not happy, they'll want to set aside their award on the basis of public policy. And we know that's a fluid concept, public policy. What is public policy?
Yeah, we will come to judicial intervention, but in terms of legal reform, I think, and I'll be candid, perhaps Abayomi and the others can share or you may refrain, but I think some of the major problems for legal reform across the continent, one, the lack of a clear vision and purpose as to the reform. Why are you reforming? Is it simply a trend, or do you want to reform? That's one thing. Secondly, it takes time to implement that reform on the ground, and people are testing this through trial and error. Yeah. And at the moment when they are about to get it right, and by the way, for investors, and Naomi will ask that, what they seek is certainty and predictability, one way or the other. It's not that it needs to be an excellent or not, but they need certainty and predictability. And when you're about to have a degree of certainty and predictability, then a second wave of reform comes in, and so you are facing the same problem. So it becomes a vicious circle. What is your say, Abayomi?
Well, very tough. I mean, I would say that, the way I've looked at this is to say, generally across Africa, law reforms, I'll grade it or assess it a success, because most countries in Africa are now modernizing their arbitration laws. In terms of judicial support arising from these legal reforms, I would say uneven. Uneven because there are good jurisdictions where you can always go and you have knowledgeable courts, like in South Africa, like Nigeria, best country after Rwanda, and some other courts where you can always get supportive judiciary. Award enforcement is also one, and I would grade that inconsistent. Inconsistent because in some jurisdictions, there are political interferences in award enforcement, even post-legal reforms. Another one is representation of Africans. I would grade this low because Africans, we have the likes of Prof and a number of people that are out there, but when it comes to representation, it's still very low. Institutional capacity, I would say growing, but we need more investment for the institutions to attain more credibility.
True, that's important to give our audience a taste of it. From my very own home country, over a period of 50 years, we've had about 5 to 6 investment legislation. So when it's just, and imagine if you have a long-term investment and the law changes and switches. In fact, it even changes radically sometimes back and forth. And so that creates a situation of uncertainty in that sense. But Madeleine, any thoughts about this?
Thank you, Professor. Thank you, Dr. Nakasamba, for laying the ground on this. And my thought on this, and I'll just keep it very short, is that these amendments or reforms that are constantly coming our way do erode the confidence in the system itself. The whole purpose of these systems are to give legitimacy and certainty to the end users, who are the ultimate stakeholders here. Now, in Tanzania, we face the similar challenge. Just when we're getting our hands around the Arbitration Act, which is a very lucid, coherent, and cohesive, I would say, similar to what they would say about the Arbitration Act of 1996 of the UK, coherent, cohesive, lucid act that can stand alone and has been tested and has gone through the test of time. However, in our legislative piece, which is a mirroring effect, say for a few provisions,
We've faced so much on-the-ground challenges that we've now seen the Legal Reform Commission put up a Bango Kikita. We call that a stakeholder engagement, where they start taking comments. And through that Bango Kikita now is where we now share the on-the-ground challenges, how implementation has not been at as what it was envisioned by the legislature. And so through this phase that we're going through now, we're anticipating that this enactment that we see as very fit for purpose is going to be now tweaked and maybe cause a lot more damage than what we're experiencing at this point in time. So that's the fear that I have with that. But if I can expand on that, the volumes in many rooms in Tanzania is the speak of having a strategy that a government commits to, meaning a policy. We need a policy. We do not need to wake up, get an email from the Legal Reform Commission that we're doing a deep dive on arbitration, send in your comments. No. It has to be done in a pipeline effect where we are anticipating. After 5 years of testing this enactment, we will do a stakeholder engagement. But we can't just because there's a few challenges that everyone puts up on the table is now awakening a big, gigantic dragon that was lying at the back of our rooms. So we're having that challenge. We do have legal reforms, despite the fact that the Act is very well structured and well harmonized to the extent that it could be. And the challenges that we're facing is really implementation of those provisions that were inserted that were not in the Arbitration Act of 1996 of the UK, such as the establishment of the Tanzania Arbitration Center, which is the TAC. This is a statutory organ. That provision of establishing this entity was put inside the Arbitration Act of revised edition of 2020. And why it's giving us a lot of problems is that we were very innovative. I think the legislature did try to now relieve the courts of the whip to appoint, the whip to come in and remove an arbitrator. So all these whips were vested on a center that is non-existent since 2021.
Yes. Now,
So that's
Naomi,
where we stand.
let me ask you this, and I'll be blunt about it. Leaving Rwanda aside, because it's right up there with the Scandinavian countries, has legal reform been successful in rooting out corruption on the continent?
Ooh, what a question, Professor. I can't answer that with a yes. What I can tell
It's
you...
a leading question, and the answer is no.
Well, indeed. What I will say, though, is, and this goes to something you mentioned earlier, I'll be very quick. You asked how we measure success, and can we measure success of whether these reforms have had an effect or not. And I have had the privilege to recommend a KIAC clause in one agreement in the last few years. And it was one, but I was really glad to be able to do that. It was appropriate in that case. I would like, and I hope others in this room will share that ambition, to be able to recommend clauses involving African arbitration more regularly, the same way that we recommend other jurisdictions as a neutral forum for international parties for whom it's appropriate, right? And whenever the conversation at the moment goes near that, one factor that still is often asked, and it may be asked in an uneducated, uninformed manner, but I still get asked, well, what about, corruption when we want to enforce? So what about corruption in the process? And so I can't answer your question, but I can say that I still get asked by potential users whether that is an issue and am I not concerned.
True, that's very helpful. Madeline, let me ask you this, and other panelists will share their thoughts on that. Judicial, we've seen that the Minister of Justice and the Attorney General has referred to judicial intervention and government intervention. And I tell you this, there seems to be a view, at least in certain parts of the continent, that judiciaries, yes, they should be independent, but as a mark or a show of patriotic act is that you should stand by the government and government entities when there are proceedings or when awards are passed against them, one way or the other, it becomes a duty incumbent on the judiciary to rectify the results or the outcome of an award by some people sitting elsewhere in distant localities. They don't know this, and it becomes, a question of, is that patriotic? Is that against independence and neutrality? Do we have a problem on the continent in terms of judicial protectionism and assisting whenever there is a state or a state-owned entity involved in arbitration cases?
Doctor, that is a very difficult question to answer. But in true sense, from a Tanzanian perspective, I see that our judiciary has been very much pro-arbitration and very neutral in terms of its approach in applying these foundational principles of arbitration. One, why I say this, and I'm not going to read what I've written here, but the judiciary of Tanzania, in a case called Marine Services, upheld and held in its judgment that it is not an appellate court. And this matter involved a state-owned matter. And it was an approach by the state attorneys to try and put aside an award by trying to get the judge to go to the facts and the law and how that arbitral tribunal arrived at its conclusion. But the court was very clear and echoed many other courts in many other jurisdictions that it is not an appellate court, and it is not a court where they would be open to re-adjudicate a matter that has already been well adjudicated before a tribunal of their own choice. That's one. And that is being consistently applied in the High Court and Commercial Division. Why I specifically focus on the High Court and the Commercial Division is because we're now seeing president-elect judges coming from the private sector. And they're very well put in the commercial court because of their experiences in the practicalities of these issues. And so, for example, we have a new judge that has also come up with another judgment where we saw he went on to rule, and I'm just going to, I think this was the Vodacom versus Planetel, of course, not very much affiliated with government, but with our telecommunication industry, there's a percentum of sovereign shareholding in the telecom industry, and there we held the award. The court held that the award was procured in a manner that is contrary to public policy. Now it comes back to the question of public policy, and that the same is uncertain and ambiguous as to its effect. And so therefore, he upheld the challenge on serious irregularities, which is a creature of the Arbitration Act of the UK, embedded in our statute under Section 74 of the Act. And so he didn't set it aside. He remitted it back so as to allow that tribunal to rectify or to at least do its best to reconsider those issues. And so we're having a judiciary that is becoming more conversant, more comfortable. I like using the comfort word because initially, if you look back 10 years, the judge would shy away from such matters because we've no bearing at that time. I think another interesting one, which I'm trying to find in my note, which may be surprise you, because our act opens up the door to access to the court, to the even lower courts. The previous legislation that was just that was put aside, that act only vested jurisdiction on the High Court, but the new act opens up doors to the lower magistrate courts and the resident magistrate courts to also be able to play a part in this particular system of arbitral matters. And so we saw a case come up. And that case, I mean, if I can look for it here on my notes, It was a very interesting case. And if I remember the name, because I'm not seeing it on my notes, the arbitral award stems back from an arbitration where I was privy as a transcriber, as an arbitral secretary, and it took part in 2018. And they bring in the award for purposes of recognition and enforcement this 2024. What happens there is that the court looked at the award and ordered that award be set aside on the basis of the argument from the respondents that the mediation report was not tabled, and so therefore there's no evidence of a report of a mediation ever happening. And when you're looking into that judgment, there's a mixture or confusion as to these mechanisms altogether in the lower courts, because a mediation report is nearly impossible. The report that they had submitted to the court was saying mediation failed. But what the judge expects is a report that this person said that, yet there was no settlement because of that and that. So, we're looking at that judgment, and we're really trying to speak to the judiciary through the Chief Justice to tell them this has to be looked at again, because this is setting the wrong scene. So there's a mixture of, as my colleagues have said, there's a mixture of impactful judgments, yet also others that sort of push us back and want us to rethink the whole system, yes.
That is helpful. Nakasamba, in terms of the point now, we know across the continent the decisions are almost standard language, no de novo review, it's not an appeal, limited grounds for setting aside. My question goes to specifically cases involving states and state-owned entities. Does the judiciary feel that there is a degree of a duty or heightened level of review when it comes to that? Now, of course, there are countries on the continent that have a dual system, administrative versus traditional courts. In North Africa, we know that. But what is the take from a Zambian perspective? Do you see any difference, or do courts treat arbitration awards no different, whether it's a state entity or not?
Well, obviously, when we're talking about judicial intervention, I don't think you can ever have that discussion without discussing the PNID case of Nigeria, right?
I'm leaving him to the last.
Yes, exactly, yes. But I think for me, that case actually does show that the system is self-rectifying, right? In the case of Zambia, I believe our courts are not shying away simply because there's a state entity involved. Of course, the state will always have defenses such as, there was no authority for this settlement, or, the agreement is invalid. But ultimately, those are issues to do with political risk, not necessarily enforcement of the proceedings. The investor needs to have undertaken the due diligence in ensuring that everything that needed to have been undertaken was actually undertaken before reaching the settlement. In our jurisdiction, and I think I did initially highlight the Stefanuti case, where the courts were very clear and they said they're not an appellate court. Regardless of how absurd and the quantity of the award was, they could not, it was not unreasonable. And I was trying to highlight some of the issues that come out of that in terms of where the challenge actually lies when it comes to state entities involved in arbitrations. The arbitrator there and the court did not shy away from stating that perhaps the state should have engaged a legal expert, the appropriate expertise in the matter, because that could have helped in actually reducing the value of the award. But I think the challenge is we sort of do take a laissez-faire approach when we're handling these arbitrations, and not to state that, and I think maybe because we're generally a litigation culture, and with litigation you generally have a system where you can build up your case and all of that, which might not be the same for an arbitration. And this is really what they face. You get judgments or you get awards against the state, and then the reason is simply because the case wasn't properly presented.
Thank you. Abayomi, what's happening in Nigeria?
So I will not go to the PNID case. That is controversial of itself. But I saw something which is very important when I was preparing for this. Someone said, reform doesn't end with the legislation. Real power lies in the judge's pen. So it is not enough to have good laws, you need to have supportive judiciary or good judiciary. The truth is that, or the sad truth, is that for most countries, the judiciary is not always independent. For most countries, the judges are always, or do always support state-owned entities. Now, I'm not talking about Nigeria now. In Nigeria, judges will always, or the judiciary will always decide, notwithstanding whether a state-owned entity was involved. And I'd gone through about 50 cases while trying to prepare for these involving state-owned entities involved in arbitrations. And what I found is that about 80% of them, the judges were quite fair in terms of their decisions. But that notwithstanding, we always see that sometimes state-owned entities they've devised mechanisms for always resisting enforcement or arbitration. There's a particular state-owned entity in the country that I will not mention, where they have two separate legal teams, one arbitration team and then one litigation team. So when you start arbitration, all is fine, but the litigation team is always on the standby. When there's an award, then they will litigate, and the cycle starts all over again. So state-owned entities are always in the habit of always resisting enforcement or not participating in proceedings. But Nigerian judiciary generally will not support state-owned entities or review an award or review a decision based on the fact that a state-owned entity is involved.
Thank you. That's very helpful. One untold story that will probably leave the people in this room just with eyes wide open, and it's not on the continent, so that it is related to Africa, but in proceedings involving a state-owned entity following an arbitral award, the judge looking at the setting aside, and I mention again, it's not in Africa, but it's an interesting case because it's a first-hand knowledge that I've come across of that. The other party, when the state filed a motion to set aside, they told them, we need to see the submission so that we can respond to it. The judge's response was, no, you don't need to see the submission. He told him, what I would respond to if I don't see the submission. He said, you will not see the submission and you have 48 hours to respond. Now, absence of due process is stark to an extent that the lawyer was stunned. How can that happen? So in reality, there are situations where you face this clear injustice. I must say that at least the continent and countries in the continent are now, striving, doing more work, because I think judiciaries have realized that really the kiss of life to legal reform comes through the judiciary. You cannot have any proper reform. You cannot have seats in Africa unless you have independent judiciary. And the mark of independence of a judiciary is basically treating the parties on equal footing, irrespective of whether it's a state entity or not. And you are actually doing the state a service by acting independently so that they can reform their practices as well if need be. Now, this brings me, Naomi, to the point that what is the perception outside the continent towards this sort of judicial intervention or government intervention? Is there a misconception? Is that something that investors or companies or even state-owned entities from other countries, like China, they are investing a lot in Africa, are they concerned about that?
Yeah, thank you, Professor. And I'm glad you asked me about perception. I think that's right. The perception is still difficult, and maybe that's a question of time, as you mentioned earlier, between the reform taking effect and sort of it actually having an impact. I want to answer that with an untold story, if I may, concerning a state-owned entity. And so what happened, there's an arbitration and a need for some urgent interim relief at the beginning of this before the tribunal was in place. And the arbitration agreement specifically said, as they often do, you can go to any court in the world to get emergency and interim support. And so in that case, the state-owned entity went to its state courts because that is where the relief would have been most effective, and got actually a fairly neutral order from the court that basically just held the ring. And foreign investor was very unhappy and got an emergency arbitrator in place, and the emergency arbitrator made orders that sort of nullified the effect of the court decision, the interim court relief. And this is an untold and very personally held view I have of this, but what I think happened there was a perception issue. You know, the emergency arbitrator was on the spot, it was very, very rushed, and I think there was a perception that, well, you're a state-owned entity, you went to your national court, and the national court gave you exactly what you asked for, and that's contrary to sort of what the foreign investor is asking for. Because when you read the actual judgment and order, had that been obtained in a third state, I don't think there really would have been any discussion about countering it with it. So I think the perception issue is still very real.
Indeed, and that is very helpful. So let me move to the last part before we open the floor for discussion, because I think we need to allow some time. Is Africa ready for really international arbitration? We're not talking about domestic cases, but hosting international arbitration seats or having truly international arbitration on African turf. And let me ask, while at it, Naomi, users, again, is there still a degree of skepticism in that sense?
Yes, as I said, I've been able to recommend an African cause once. I would love to do that more. And we need the tools to do that. You have to persuade someone that they can't use their default. Often, you know, legal teams in big corporations, they have a default set of clauses they're allowed to agree to. So we need to have the reforms and the stories and the consistency, to your point earlier, to be able to say, actually, you should come away from that. I think we're ready. I think it's just that the perception has to shift. I think it may take some time.
Thank you. That's the user side. Abayomi, arbitrators?
Yes, I think we are ready, but I would say systemic underrepresentation marks the readiness. We have qualified, yourself inclusive, and many people in the room, qualified practitioners in the continent that are able to take on complex cases. There's always a perception of not having enough good hands, enough qualified people within the continent, and like the Honorable Attorney General said today, that perception may not actually be true, because we have people that are doing a lot of complex work within the domestic sphere and also international cases. They may not be out there yet. I remember many years ago when I was doing largely transactional work, it was just within the confines of my office. Nobody knew me until I started coming out for people to know. So maybe we need more visibility in terms of what we are doing so that people can trust our work and then have that confidence to appoint us, right? And I've also been involved in cases where we've advised clients, yes, I was in Malawi 2 days ago, and I met with a potential client that has a dispute with another Malawi-based entity, and both are Malawian institutions or companies, but the agreement has one English law as the governing law, and also London as the seat of the arbitration. So what happens is that today they are struggling to conclude the arbitration in England, paying legal fees to English qualified lawyers, and also resolving that dispute essentially in London, which they could have done maybe in Malawi or go to AFSA in South Africa. So the question again is, or the concern is, we have to look inward, and Africans should appoint Africans so that we can begin to enlarge that pool. I've advised clients before that when you advise them and you put forward an African as a potential candidate for nomination, once they see an English QC on the other side or being appointed by the counterparty, they will simply say no, right? Because they believe Africans are not able to match or may not be able to match those English QCs. And that may not necessarily be so, right? So we need to give that opportunity to Africans to, learn more and also put forward whatever knowledge that they have.
One of the main problems, and I struggle to understand, is that the idea that African arbitrators, or even practitioners, and I'm going to come to Nakasamba, that are only good, potentially, for African arbitrations, or Africa-related arbitrations. I don't know where this is coming from, and I don't know why this is the case, especially when we have colleagues from the UK, from Switzerland, from France, from Latin America sitting in cases. And the mark of being independent is that you have severed any link with your country or continent or whatever, and you're able to sit. So I think we need to rethink the approach that looking at African arbitrators are good only for Africa-related work. And that, I think, needs to change. And part of it is changing that conception. Of course, competence, qualification, expertise, experience are all needed. But I think this is one of the main issues, is that so far the discourse and the discussion is focused on, oh, you need at least one African in an Africa-related arbitration. And I struggle to understand the logic or the rationale for that. You may have Africa arbitrations not involving any African arbitrator, and you may have Latin American cases involving 2 or more African arbitrators. What is the problem? I don't understand. Nakasamba, Council, yes. African Council, are they ready, or they continue to take the back seat?
I think the answer to that is we actually don't have a choice. We have to be ready. I am ready. The question is, are you ready? And that's all we should be doing, ensuring that we are ready. I mean, you have talked about arbitrations outside of Africa, but also even on the African continent. We're undergoing the African Renaissance and Africanization of our cases here on the continent. And I think what's important is for us to recognize the opportunities, because it's the only way that you would then ensure that you are ready. With AFCTFA coming on board, this is not just an economic agreement. This is going to open doors. So the answer to that is we must be ready.
Institutions?
Thank you, Doctor. And I echo everyone on the panel that we are ready. Africa is ready. So are the institutions. We're sitting here in Kigali, and KIAC is championing this together with the ICCA. And this is a great platform for institutions such as the KIAC, such as the Nairobi Center, such as the rest within the region and continent-wide. And so therefore, I would say, in terms of the role the institutions play in enabling and creating platforms for administration of these matters, we are very much ready. Just to add on maybe to the fact that, yes, ready, as we've all said, but a little bit more work to be done. And that work, from my specific jurisdiction, will be to enable now, to give the government support to institutions, much more institutional funding from not only private but also public players who utilize these resources, and so to get the infrastructure ready for the bigger bite. Yeah. Thank you.
Thank you. Now, we're ending this. We may have a couple of questions, but I will only say this. When people say we're ready, just my advice is be careful what you wish for. Because when you say you're ready and you are not ready, it's the end. But anyway, Chief Bayo Ojo, I think we'll take a couple of questions. And we have a number. The Nigerians are taking the lead.
Thank you, Prof, for that. Let me say that I'm very, very impressed with this panel, and I want to commend each of you for your contributions. In the course of the panel, your discussion, Nakasamba and Abayomi mentioned the PNID case, which Abayomi said was controversial.
I intentionally did not touch it because you are one of the arbitrators.
Incidentally, I was one of the arbitrators in that case. But my question really to you, Abayomi, is that do you think the outcome of that case influenced the new national policy on arbitration being put together by Nigeria? Do you think the outcome influenced it?
Excellent. Thank you very much. And I think I should have mentioned the national arbitration policy, which is very, very important. I mean, so the policy has been in the works for a while, right? So maybe that was what crystallized that policy being finally published. Well, I mean, so a number of things from the policy. The policy says Nigeria will be the seat for government-related arbitrations. Nigeria will be the seat of the arbitrations. Nigerians will be appointed as arbitrators in those cases. P&ID is very complex and complicated, and I'm sure if we start today, we will not finish. And more so, if we need to read the books, we don't need to read the books, we need to just sit down with you to learn from you because you are one of the arbitrators. So I would say that, yes, maybe one of the reasons why it was eventually published, because I know at some point I was involved with other stakeholders like Ms. Adekoya to react to that policy. Maybe that was why it eventually crystallized in terms of being published. I mean, Nigeria would have lost a lot, assuming that award was eventually enforced. But thank goodness we're where we are today, and that the award wasn't enforced. So, yes, the policy, the proprietary, the benefit or otherwise of the policy is a separate discussion, and I don't want to go into it because we can also debate that. But I think, I mean, in a way, the policy would develop arbitration in Nigeria, and there's before we used to to have that fear, but now we have that reassurance that there will always be food on our table, given that policy. Yeah.
Yes, Professor Dorothy Ofut, Senior Advocate Nigeria. Let's limit this because I think we'll have to wrap up in less than a few minutes, 5 minutes, although we started late, but yes.
Hello? I'll try to be quick. My name is Dorothy Ofut. I come from Nigeria. And Prof, one of the questions you put to Naomi was, has legal reform been able to stamp out corruption in African arbitration? That was indeed very provocative. It's a topic that people are reluctant to talk about, but it is a topic that as African arbitrators, we must all confront. And my take is that corruption has nothing to do with legal reform. Corruption is a personal thing. It's personal to each arbitrator, but it's a factor that militates against African arbitrators and arbitration in Africa, particularly when you're considering choosing when the investors are considering a seat. Fine, we all know that perception is 90% of the reality. So I think that it is a topic we can set up. We have witnessed a proliferation of arbitral institutions in Africa. Yes, it's a good development, but that is really not the issue. We must actively, collectively deal with the perception of corruption if we are going to move forward. It is really, really militating against us, and until we deal with it publicly, no matter how provocative it may be, then we're not going to make any substantial progress. Thank you.
Thank you. Isaiah, and then yes. Isaiah and then Klaus.
Thank you, Professor, and I understand the importance to be quick about this. I just wanted to pick up on something Madeline said earlier, which is to do with having a coherent policy in place. And the question raised by Chief Bayojo also spoke to that, because I feel the policies I've seen so far have been reactions to certain events that have taken place. And that causes bigger problems down the road. So, Professor, you asked the question, would a state court, for instance, feel an obligation to side with a state entity? And you would have to look at the relationship between what the judiciary and the executive is. So, for instance, in some jurisdictions, and I won't mention any specific names, there is no real financial independence of the judiciary. So if the judiciary is dependent on an executive for financing, then they may feel beholden to them in terms of being loyal. So I guess is an unasked question, what are we reforming for? And more specifically, how do we get there? Who is taking responsibility for each of the different elements? And I just, well, if there is time, of course, I'd love to hear perspectives, but I'm sure it will be a discussion for another occasion.
Thank you so much. Is there any immediate comments? I think the last question will be Klaus, because we need to wrap up, but yes.
Thank you very much. I would like to express my admiration for the conference here in Africa. I come from a developing country. I come from Mexico, even though my name is not very Mexican, but German name, but I was born in Mexico, grew up in Mexico, studied in Mexico, had the chance of studying in Paris, and got in touch with arbitration in the early 80s. In Mexico, arbitration was non-existent. So the conference today reminded me through the process we went in Latin America, the transformation of our laws, our institutions that were created, and I can tell you that we went exactly to what you are going through, and I only can assure you that you're going on the right track, and you will be a participant, very important participant in international arbitration. In Mexico today, the 23, Mexico was second place together with Germany after the United States in the country with most parties in arbitration. But in 1980, there was no arbitration in Mexico, in Latin America. But today, Latin America is playing a big role, and I think Africa is in a similar situation as Latin America was in the 80s. So I encourage you to continue what you're doing. I think doing a conference like you're doing today, exposing the world to arbitration. I think you're in the right track, and I congratulate you for this excellent conference that we would really like. This is a top conference, one of the best conferences I've been in the world, so I really congratulate you, and of course, ICCA to have chosen to do the conference here in your country, and I encourage you to continue, and you will not only be important in the world arbitration, but you as arbitrators will be sitting in arbitrators all over the world, as many of us from Latin America that started in the early 80s are now doing. So continue the way you're doing, and you will achieve your goal. Thank you very much.
Thank you so much, Klaus. There is a lot of lessons to be learned from Latin America and from the West, and I think African jurisdictions and decision makers are looking at that. Now, what remains to say is the following. This is the start panel for a day of untold stories, but I'll leave you with one thought. What shapes the human mind and the heart are the stories that we are told when we're very young. If you look about babies and newborns, the first seeds of knowledge are planted through stories. The story will continue, but I will ask and thank my panelists for their insightful comments and thoughts. Thank you very much, and I wish you all the very best. Thank you.
And your panel, thank you so much. You've been generous with your time, because I was so much worried as the MC that we are running right behind. So what's next? I think you deserve a break. But we will have to do some adjustments. I ask that you support me in this, because we have a very long day. I ask you to go out for a short break of about 10 minutes. We have a very, very interesting interview coming right after the break, and the interviewer and the interview should take the stage right after the break. After 10 minutes, please. Please, we have 1 hour at lunchtime. I promise that. Thank you so much.